Staying with us here on the program tonight, BBI, it's a single issue bulletin tonight. My guests are already here with me, Paul Mwangi, Elias Mutuma, and Herman Manyora. Gentlemen, thank you very much. I know it's been a long day for everybody, whether you were in court or outside of it. I think all of us were following the proceedings. I think, Paul, the best person to start with is you, having been in the BBI Secretariat. What, in your view, is the status of BBI in relation to the judgment today?
Where we stand now is that we lost only two things. The first is that out of the contents of the BBI bill, we have lost the second schedule. That is the only content of that bill that was declared unconstitutional. Everything else that was in that bill was good to go. The second thing that was faulted is that the popular initiative that was started was said by the judges to have been tainted, and tainted because they said that the president involved himself in it. So our reading of it is that what we have lost is just about 4 months, because what the judges are saying is that if you go back to square one, start your signatures again, ensure that the state and the president are not involved, and you remove the second schedule or do public participation for the second schedule, then you're good to go and you can start it over again.
Elias, status of BBI now?
It's dead. The final nail on the coffin was today with the judgment of the Supreme Court. But I think it's also good to appreciate the fact that BBI as a process was not an issue. It wasn't a problem with us. It is using BBI as a means to amend the Constitution that we had a problem with. So to that extent that it was a means to amend the Constitution, that is a process that we cannot revisit. Yes.
And we'll get into the substantive issues in a moment. But Herman, what is the state of BBI now?
Well, I think like Uhuru said, one day, sometime, one day, BBI will be back. Raila said he's on half-time. I think that is the situation now.
So you think there's that it has, in a way, probably clarified, how the process could possibly be done again sometime in the future? Because there was never going to be a factor before the August 9 election, either way, right?
In fact, what the court said today, BBI was okay. This referendum can go on. If you purge the whole thing of the two things, everything else is okay. Because I admire this young lawyer here, but when he says coffin, I thought the whole thing was about whether or not Kenyans can amend the Constitution. And that has been addressed well, clearly, during the day. That yes, indeed, contrary to the thinking and opinion of the High Court and the Court of Appeal, Kenyans can indeed amend their Constitution. And that was the only question, really. Okay. And it's been answered today.
Interesting. Now, when we get into, the issues that were at heart, one of the biggest ones was obviously on the president and his involvement in, amending the Constitution via a popular initiative. And Paul, it's instructive to note that this is an issue that you have lost 3 times. The High Court, at the Appeals Court, and now at the Supreme Court. That's 3 strikes for this issue. My question is, did it have to get to this point? What does this mean for having this matter struck out 3 times with respect to this issue?
Again, the word having been struck out is being wrongly used, because it then appears as if the whole process has been outlawed. First, the whole challenge had been made of the entire process. The task force has been upheld throughout. The steering committee process has been upheld throughout. What has come to haunt BBI has been when the promotion started. And 2 of the judges still say that if you look at the evidence does not show any wrongful involvement of the president in the process. 5 of them did not think so. But then what would that mean is that if you were to go back and start it in a way that is divorced from any state organ, then you're good to go, as I said. But the other thing that was being challenged is that BBI was being told that there are things you cannot amend. We were told we cannot have an expanded executive. The judges are saying we can have it. We were told we cannot have a judiciary ombudsman. The judges are saying you can have it. The judges are saying you can amend, you can have anything you want, long as you go through the process.
But we will get to that in a moment. But, the one fact that the president won, and it was, I think, in 2 parts, that one, the president or a person holding or, conducting functions of that office cannot initiate the process, but they then went further to say that the president currently did in fact do it. CJ Martha Koome, in fact, went into it, talking about the communique in March 2018. It was, on government letterhead, there was a seal, that sort of thing. That in itself, was a big death blow to the whole process.
What I understood the judges to be saying is that looking back at the process, the president has been involved since the start of the task force.
Right.
And what they would have wanted to see is a better disengagement of the president, so that what they are saying is a thread that runs through from the task force coming all the way to the promotion. Mm-hmm. And the fact that even when the signatures were being collected, the president was in attendance. And they're saying that the attendance of the president at that time, they do not accept that he attended it as a private citizen. Yeah. And they still say that he carried the presidency into the process of promotion. And that is what they have illegalized.
And this was the issue, I believe, that you brought up, Elias. This was in your petition, wasn't it?
Correct.
Yeah.
I think let it be understood that we did not have, like in our petition, we did not challenge any provision of the impugned amendment to the Constitution. We only challenged the process and the people who initiated the process. In that we are saying, under Article 257, that is an avenue reserved for the normal mwananchi, for Wanjiku to amend the Constitution devoid of state actors. And that's what the High Court, the Court of Appeal, and the Supreme Court have confirmed, that you cannot have state actors in the name of the president, in the name of parliament, in the name of any representative amending the Constitution, yet wearing the hat of Wanjiku. I think that should be understood.
All right, and there was also the issue of basic structure that came up, Herman, being a key component of the petition, which some would say, and I'll come back to you, Mutuma, was perhaps a loss for the other side. Talking about the 4 steps that are requisite for amending, and saying that that is only reserved for when you're making an entire constitution afresh. And in fact, they went on to say that, I believe it was Justice Smokin who said the basic structure was overreach and a creation of the courts. This being a major issue, even though it was not something that was in our lingo as Kenyans, now we are dealing with matters of basic structure, Herman.
It wasn't a major or the major issue. It was the only issue. And sometimes I'm a little unkind to lawyers. But I say lawyers went to court to speak a lot of English. They should just have reduced this thing to a very simple, basic thing. All these others were side issues. The question is, a group of Kenyans wanted to amend their constitution in a manner provided for by the Constitution. Another group of Kenyans went to court to stop them. So the question before the court should simply have been, who is right? The person seeking to amend the Constitution using the provisions of the same Constitution, or somebody stopping them. But you see, there are so many issues were introduced. And therefore, me, I see the pronouncement on the basic structure as the most important thing today. The rest are simple things. If you want to ask yourself, if you want to know this is important, ask yourself, so going forward, I see some people are celebrating, everybody's happy, and others are over-celebrating. But even if the court had granted Paul Mwangi and his team the prayers, all of them 7, and say BBI is good to go, would they have had the Constitution amendment before the elections, the referendum? Certainly no. It would have been after the election. Now, if Raila wins, can he then move into changing the Constitution? The answer is yes, because the path, the door has been opened. Somebody had locked it and thrown the keys. Like enough, Justice Mother Koome found the keys. I think they were throwing them in the Indian Ocean, but it fell on the shores, and some beach boy picked it and rushed it to the Supreme Court. So really, to me, to answer your question, is the basic structure is all there was to discuss in the Supreme Court. And I like the way Mother Koome presented it so clearly, in a simple, straightforward manner in which even a primary school kid will follow. And that's how I would want going forward. When we have a matter to resolve, let us do so in a very simple way. I must also add that in future, anybody who feels there aren't enough safeguards on this issue of basic structure. If people feel, and I think we could feel so in future, let them move to the people and ask the people, we want to improve the safeguards. Yeah, we want to make it a little more difficult to amend our constitution. And that's the way to go as people, if you love your country. Yeah.
But the judges did say that they felt that there was, enough of a balance between the two, the rigidity and the flexibility to do so. But Paul, I want to ask you, the issue of basic structure, and we heard quite a bit being said about, where it's applied and applicable in countries like India. But correct me if I'm wrong, basic structure, is that not something we have done before? Gone through those 4 steps with the Bomas draft in 2005, the Kilifi draft as well, including the Constitution of Kenya 2010, where, all those 4 sequential steps, public participation, constituent assembly, civic education, and a referendum, that is something we've always practiced, or haven't we?
That is what we did when we were promulgating this constitution.
Yeah.
And that is why I agree with Professor. That was actually the crux of all the litigation that has been going on. And that was the most dangerous thing. And the inconvenience that has been caused to BBI now, to me, is not the issue. In fact, from the point of collecting signatures to get into Parliament, we took just about 4 months. So, as Prof is saying, it's very unlikely, even if the judges had told us to go ahead, that we were going to be able to have a referendum before the election. So the question is the amount of time that we need to go and restart the process. What would have been very dangerous is if the Supreme Court had upheld what the High Court and the Court of Appeal had done, because that would have made the Constitution of Kenya unamendable, almost literally, and would have been made it very fast. It would have totally outlawed the entire BBI process as a way in which you can amend the Constitution. That has been opened up. And they have said that what the judges were recommending can only come to play when you are you're negotiating a new constitution. Yeah. But that after you've done, when we were making the constitution, we knew about basic structure. We did not follow it. We knew about the Casavanadra case that the judges were following. We refused to follow it. And they're saying that we must take it, that Kenyans, knowing that all these things existed, refused to follow them and instead decided to have their own amendment processes and said that we must respect. And judges cannot allocate themselves the position to think that Kenyans did not know what they're doing and therefore create what the Chief Justice called the fourth pathway.
Elias, you said BBI is dead, but what do you think this means for any processes in the future? It may be the Building Bridges Initiative, it may be another. I mean, we saw Punguza Mizigo that even preceded this process. And I think, it was outlined that there have been several attempts to do so in this, perhaps in a popular initiative or otherwise, parliamentary. But what do you think, the entire decision today portends for any attempt to amend this constitution in the future?
Thank you so much. BBI was suffering from a myriad of diseases. It succumbed to one today at the Supreme Court. That is the issue of popular initiative. Number 2, what does it portend is that the Supreme Court has given us guidelines on how to amend our constitution, what we should amend and who should amend the constitution. Punguza Mzigo and NASA's attempt to amend the constitution did not go very far because, again, we did not even understand what route we are supposed to take when we are amending the constitution. Like I said in the morning in this very show, that we expected the Supreme Court to give guidance in terms of developing the law, expanding jurisprudence, and settling legal quagmires.
Do you think they did that today?
I think to a larger extent, they have done, because when you look at the issue of a basic structure, that is now settled, that we do not need to apply the basic structure. And by the way, that's a binding finding. We cannot go anywhere else to find that we have a basic structure. So I think in terms of expanding jurisprudence and settling that specific issue of basic structure, the Supreme Court has come out clearly and settled that matter in a unanimous manner.
Yeah.
Yes.
Obviously, there's the big one in the room now about the political implications. And for this, Mohammed, I think you're best placed to talk about it. So there's been quite some investment, emotional and otherwise, in the BBI process, at least on the part of the proponents. What is the political implication for this? Because this is it, it's done, Supreme Court, apex court in the country. what happens next for those on either side? What does this mean for the proponents? What does this mean for those who are against the process?
I think the whole thing must be tied to the verdict itself, to the judgment. Look here, if they had given the proponents, who are the appellants today, if they had carried the day on all the 7, and therefore given the green light for them to continue, they were going to celebrate, and I'm happy Paul is here, but that celebration was going to be very short-lived, because the other side was going to step up this argument about tutashughulikia uchumi na kazi za vijana wetu ama tutashughulikia vyeo za wakubwa. That was going to be a big narrative. It was going really to injure them. And of course, you must also accept that it was going through a lot of confusion in the whole political space with the elections coming. You know, really, it's going to be a big thing, kind of shaking the election. In terms of who then should celebrate and what it means to the way it has been brought up is very good, because, like I said earlier, the side that were opposing BBI are really celebrating. I heard William Ruto talk about it, Musalia Mudavadi, Wetangula, they are very happy about it. I heard also Raila has said he's happy with it. Paul Mwangi is here, he says he's okay. Everybody is okay, and I think that's good. But from a political point of view, there is someone who has lost more than the other. For example, if this thing had gone through and Raila wins the election, William Ruto was going to enjoy some cool office, official leader of the opposition, fully funded for by government, with a shadow cabinet and all that. Now, if Raila wins, Ruto will be very far away from government. Remember, I've always argued, in this election, the victor will vanquish the loser. And vanquishing the loser will be very difficult if he's being funded around you as official leader. So to that extent, if Raila wins, as I suspect he will, Ruto has also lost. Secondly, the bragging rights, the things people were saying about BBI from the Ruto side, they can no longer say them, because they may say so in a rally, in a cheap way, because if the reality is put on the table, it simply means they are the ones who have lost. Because this amendment, this debate, this thing in court was about people mutilating the Constitution. Wanaharibu katiba, they mutilate the Constitution. But the court has said no. Amending your Constitution is not mutilating. So one side really doesn't have much to celebrate about. And from a political point of view, apart from talking about reggae being stopped in political rallies, the reality on the ground is that they have lost a little more. On the side of Raila, they are also happy because this thing was going to injure them if they were given all of it. But to the extent that the main issue, and in my thinking, the only issue has been decided in their favor, and if they are going to win the election, they are going to put the Constitution in place, I think they are the ones who should celebrate.
Okay. I want to ask you, Elias, but I will avoid asking you a political question. I know, I will get to you, because I know you sort of, having been in the BBI Secretariat, you can straddle both worlds. But Elias, what next? What do you do with this judgment now? What happens next? How does the country move forward?
I think it's good that we have this judgment, because we know that our Constitution is safe from mutilation. And it saddens me, and it's really unfair for us to talk about the amendment of the Constitution with the election in perspective, and with Raila and Uhuru and Ruto in perspective, as if they are the only people who matter when it comes to matters Constitution. So I think from here we go back and realize that it is not about politics, it is not about politicians, it's not about specific individuals. This is our Constitution. I mean, we should protect it and defend it when that time comes.
Okay.
Yes.
Paul, you get the final word, because you wear both hats.
Yes. First, in terms of political consequences, first I agree with Prof. that one of the big loss from the politicians who were against BBI is that some narrative has been taken away from them. After this weekend and after exercising the bragging rights of the delay, then you'll have to create a new narrative, because the narrative about there being constitutional amendments as opposed to economic development, now that is gone. But they suffer from another problem, which is that so far they are the only camp that is being unable to accommodate some really big egos and positions among themselves. With BBI, they would have had something to promise. Now they have nothing to promise. So whoever falls on their part falls for real. So that is a problem that only them will suffer. I think for Honorable Raila, first he's able now to concentrate on the election, which could possibly, there would have been many issues still to deal with had this gone beyond here. Mm-hmm. And it's also able to, I think, take on a presidency without anything on his in-tray that is already predetermined.
All right. Because is it something that you would consider? You are in the BBI.
No, that's what he is free. He is free to look at this, to look at whether there are mistakes done and how he would want to correct those mistakes. He does not come in, because if this was done, we are saying it would possibly have been very difficult to do a referendum before the election.
But the same could be said, Paul, of it politically on your side, because, you know, you also have there's quite a few leading lights in Azimio. So how are you going to sort out that issue? Who gets the running mate position? Who gets what should have been a prime minister's position? So you have probably the same issues on your side as well.
We have more amicable relations on our side, clearly, from what has been happening. And then I
wait and see. I think we shall have to wait and see.
And then I think there's a third consequence in that Uhuru Kenyatta retires now with a job on his in-tray.
Which is?
Which is whether he wants to... He was told you can't do this as president. He's soon going to be a private citizen. He has a job for himself, where he could decide, now that I'm a private citizen, I'm now going to take back my project and do it as a private citizen. So I think we might see him back active politically sooner than we think.
That's a good place to leave the conversation. Thank you very much, Paul Mwangi, Elias Mutuma, and Herman Manyora. It's really a pleasure to host you all today. But I've seen a couple of you asking, you know, is it done? No, we're not done. The news gang will be here. I'll be joined by Linus Kaikai, Francis Gashuri, who was at the Supreme Court, Jamila Mohammed, and there is much more to discuss with that. That is all when we return. We're taking a short break first. We'll be right back with more.